Hello, thank you for joining us today. My name is Ian Mitchell. I'm the head of the leasehold services team at Anthony Gold. I'm pleased to be joined today by David Robson, an expert valuer who deals with lease extensions and collective enfranchisement claims in conjunction with the leasehold services team here. David and I thought it would be of interest to our clients to discuss the distinct roles between the lawyer in terms of a lease extension claim and the valuer. So over to you, David. I mean, sometimes these things start with you getting an instruction to carry out the initial valuation. I mean, how do you approach that task?
Well, each case is very much on its own merits. A property lease is the key driver for these valuations, and we do actually still need to inspect property to know what we're valuing in the physical form. But essentially, we're looking at the lease and we're valuing the compensation owed to the freeholder for granting a lease extension on the given terms. So typically, we're actually valuing where a lessee qualifies for a statutory lease extension on 90 additional years and the peppercorn ground rent, and we're duly calculating that compensation for the freeholder.
So you're going to be looking at the price payable under the Leasehold Reform Housing and Urban Development Act 1993, and that's regardless of whether the client thinks they might get the thing through informally, get the extension through.
That's right. I mean, if a client has owned the property for more than 2 years, they will qualify for a formal approach under the statutory provisions to seek that lease extension. But we often advise, actually, in the first instance, unless they've got a notorious freeholder, to actually try an informal approach and see if they can agree the matter without actually engaging with the statutory process.
But that 93 Act valuation is the base. It's a tool for negotiation,
Correct,
isn't it?
that's right.
So in the case where maybe your efforts, your endeavours doesn't get the client the negotiated deal, you're going to refer them to get legal assistance to produce a 93 Act notice of claim. And your valuation is going to give some distinct guidance on the possible valuation parameters.
That's
and
right.
Also the figure to go in the notice. Do you want to maybe just run me through your...
Our valuations will ultimately comprise of three main figures: a best and a worst case where we'd expect to agree the premium, and a figure for serving the notice. And the reason for that last figure is because there should really be a reasonable figure offered in the notice amount, otherwise you run the risk of having the notice being found to be invalid by the freeholder. So to make sure it's carried out successfully, we make our recommendation for the offer amount in that initial notice, and that's really when we pass it back to the client and yourselves to then go ahead and serve the notice in accordance with that advice.
And sometimes we might come back to you, David, because we find the valuation element actually needs to be split up between various landlords on a complex title. Again, just talk me through how it really is a combined exercise between the lawyer and the valuer to identify how to split that up.
Very much so. I mean, we often, we always ask for any deeds of variation and try and get the title documents as well.
Yeah.
And that in tandem with the actual lease, that can give us indications of whether there are other interests to account for under the methodology of the Act. But yes, you're right, there are times where it does become apparent later on that there is another interest, an intermediate lease interest, that might be needed to be accounted for in that offer amount or in the initial notice.
And when might they be very valuable? Just gives an example of when maybe the middle interest is valuable.
If they've got a long reversion between their head lease and actually the actual occupational lease and the head lease, if there's a long reversion there, then obviously there is an additional element of interest there to be calculated over and above the usual splitting of just a ground rent between the head lessee and the freeholder. So they can be quite significant as that apportionment. Albeit that said, there are other complications to it as well. I mean, how you actually detail that in the notice can be very different to what actually the respective parties get paid. And that's again where we
very much so. We have come across occasionally infighting between the various landlords on how the premium's split. You must come across this. I mean,
that's right.
And what we try to tell clients is, I mean, sometimes we don't have to deal with all the landlords in the chain. We just have to deal with the actual relevant landlord whose conduct of the claim, which is in most instances the freeholder. So it's the person who's got enough title to give you your additional 90 years. They'll be the relevant landlord. So we've got through so thanks, Dave, for giving me some insight into how you approach valuations. Another thing that a lot of clients ask us as the lawyers is how does this marriage value factor into low lease extension. So how does that? How would you answer that to a client?
Well, the way the Act's drawn up is that any lease under 80 years attracts marriage value. Probably the simplest way to explain it is really what we're looking at there is what is the property worth with the long lease, and what is it worth with its existing short lease. Now, a long lease, for the sake of argument, let's say is anything above 80 years, strictly speaking, to be safe, it should be longer than that still, because the market might reflect a slight discount. But what we're saying is, okay, with the extended lease, let's say for the sake of argument, a property is worth 500,000, and with a short lease, let's say it's worth, on its given terms, 480,000. So there's a 20 grand difference between the two. And what we're saying with the marriage value is that you effectively are splitting that 50-50 between the freeholder and the leaseholder. There is more to it than that, but that explains it, I think, well enough in a nutshell. So
we've got past the point where you've kindly assisted me with the valuation split on the notice. We've served that notice. The landlord sends their surveyor around. What perspective is the landlord's valuer going to be coming at this from? Well, the
reality is, with these valuations, there are a number of variables which we are looking into when we're actually assessing the value. The initial report we provide when we give you that upper and lower range is really to cover, to the best of our ability, what we think the reasonable parameters are for those variables. And naturally, the freeholder's valuer is instructed by the freeholder. They're going to be looking at the most favourable view of those variables for their client's interest. So it's not unusual for them to be at the upper end, and in fact, it's even more common that they are above our upper end.
We call it the inflated response.
The overinflated opinion of the value as a counter notice.
And that can be a scare tactic sometimes, can't it, David?
Well, it can. I mean, there's actually no stipulation for the counter notice offer amount to be reasonable, unlike the initial notice. So therefore, we've had numerous examples, between ourselves, where the freeholders have come back with massively overinflated opinions of those values initially, and then of course, when we actually get to
we try and tell the clients as well. We're trying to tell the clients not to be too concerned when this occurs. It seems to be sometimes it's increasingly common practice, isn't it, David, that landlords will do this.
And some landlords are notorious for doing so as well. Others are taking more of a pragmatic view, and it does just depend on the issues as well, what's involved in each case, and that it is very much a case by case basis.
So on the difficult ones where they do come back with the inflated prices, those are the ones where we're going to be gearing up to go to tribunal. We're going to get those. So I'm going to start those proceedings off, and we're going to get directions from the tribunal. There's split directions. Can you talk our audience through what those directions will be on the valuer side?
I mean, well, from our point of view, we would have to actually exchange valuations. The reality is that is a slightly different criteria to what actually has probably happened already, in as much that we would exchange valuations very on in the process as part of the negotiation process. And we have a 6-month period effectively from receipt of the counter notice before the claim effectively is deemed withdrawn. So in that time, we hope that we've exchanged valuations and we discuss the issues and we reach an agreement. But as you say, when you get to the direction stage, you've had no luck with trying to reach that negotiation or an agreement on that negotiation. You then have these directions, which first of all we've got to send through our valuation, which really, that we should be then having an eye on the fact that our role is now starting to change a little bit. Whilst we are initially instructed for the best interests of our clients, anything to do with the tribunal, actually we're acting as an expert, and that's when actually we need to be making sure that we're giving our honest opinion of what the values are. So we exchange our valuations. We then have a period of a few more weeks before then we have to then agree our statement of agreed facts and disputed matters. And that does list out exactly that, what we do agree of the variables and the facts of the lease.
What's the hardest thing to agree on the bulk of these? I mean, what things?
The bulk of the matters come down to the relativity, I would say, in my experience.
Maybe give our audience an explanation of what relativity is.
Relativity is the issue of the marriage value. Relativity is the figure that we often discount the long lease, or in fact is actually the effective freehold value of the property. We're discounting it by to reflect what we think the value of the current lease lease value is. And
is there
marriage
different ways of approaching that issue depending on whether it's a central London or
there are,
non-central?
and it's even then case by case, and we are fundamentally driven by market evidence on those. Having said that, it's not very common that we come across situations where you've got the same lease or the same lease term on a property that is sold, a similar property that's sold at the same time as your valuation date. So often we have to then refer to published data. There's RSS guidance on what relativities can be, and it's really the role of the valuer to try and argue as well, initially as favourable as possible, but when we start going to tribunal, it's got to be then a real opinion based on our experience of other cases, agreed matters, tribunal knowledge, to make sure that we are standing up there giving our honest opinion.
Sometimes there's actually a sale relevant to the subject flat as well, David. Just say there was a sale of the flat and the notice that instigated the extension process was assigned to the new owners. How does the purchase price that was paid at the time of the sale, how does that impact on the valuation issues?
Well, it has to be taken into account because you're effectively setting evidence of that short lease sale because someone has bought the property at that price, reflecting that lease length, but it's also reflecting the fact they've got the benefit of that notice, which actually the Act says that we've got to disregard.
Do you think people should prospective purchasers should almost get some valuation advice prior to formalising the completion on a low lease flat?
Correct, and I would advise anyone buying a low lease flat gets advice beforehand. Because there's another issue there is that by assigning that notice you get to carry the claim on straight away, whereas if the actual purchase happens without any notice being served, then you have to then wait for 2 years until you qualify. That's 2 years of ownership before you can actually validly serve a notice. Otherwise you're at the mercy of the freeholder, and that's at their discretion on the informal route. And depending on your freeholder, some could be reasonable, others could make it.
What percentage of our landlords do you think on the matters we deal with or to the scale of being reasonable, and what percentage are unreasable? Let's not name anybody.
It is varied. It is varied. But for the most part, freeholders they've got their interests. So they own the freehold.
Principally, it's a business, isn't
it?
Yeah.
So they're only looking after their interests there, and as anyone would do if they were in the
they want to maximise what they get out of the transaction.
It's an investment for them, so they just make sure.
And their lawyer's agenda and their valuer's agenda is very much maximising the premium outcome and the costs recovered on their side too. David, let's talk a bit about what happens when the case is actually fixed for a hearing date, and the client's concerned this is now spiralling towards a physical determination hearing at the tribunal. Let's talk about our experience on that front. When is it? In your experience, when do these things settle? Is it?
The reality is, we've been involved in cases where they settle actually at the door. You can still be trying to reach an agreement up until that point. But as I say, we've still.
Let's give that worst case scenario, David. Just tell our audience, how close we were to agreement and how we had to attend. Let's not give the client specifics, but let's give them the scenario.
Well, we had a scenario where a freeholder, to my mind, had taken a completely the incorrect view on a valuation of a property and using totally the wrong comparables, a matter that should never have.
They weren't even qualified to.
Well, they weren't even qualified, but they also
value in that instance, were they?
They were not. But the situation was what it was, and we were very different in our opinions of value, using what I deemed to be incorrect comparables. And the matter, we were significantly apart. This is the problem. When going to tribunal, you've got to. We're not only actually just focusing on the premium that the leaseholder is paying, it's also the cost for getting there as well. And there's a risk also against tribunal. It's not to say necessarily the tribunal is going to agree with your opinion. In fact, very rarely do they fully agree with one side's opinion.
Wasn't there a deal for this case specific example? I remember, David, there was the underlying reason why the other side, the freeholder, didn't settle was they wanted a bumper ground rent review. They wanted to implement put a ground rent revision clause in the lease that would adversely affect the client's interest. They actually offered a discounted premium if we agreed to their adverse terms. But the extension price was very similar to what they were offering with the adverse ground rent. I remember they were after about 16,000 for the extension on a statutory basis. We said it was worth 5 or 6, but they said you could have it for 5 or 6 if you agree a £250 ground rent, doubling. I think it was doubling every 10 years. Now, David, why didn't we in that case agree that ground rent?
Well, that's an onerous ground rent. I mean, the problem is that this is when you deviate from the statutory terms. Where you've got to watch out for what you're agreeing to. Now, in this case, we were protected because we had a claim in under the 93 Act,
yeah.
So the client had that already safeguarded. But when you're actually dealing with non-statutory terms, normally on an informal basis as well, the leaseholders got to be very careful what they sign up to, because that type of ground rent that you refer to there is onerous, and it causes problems on resale. So you can not only, you looks like you might be paying a nice low premium, but for a start you're paying a ground rent which you wouldn't otherwise be under the Act. You've invariably agreed to a shorter length of lease than you otherwise would have got under the Act, and ultimately you could have a real problem on resale because of the situation with the excessive ground rents being paid.
So that was a case specific example, and we never. Collectively, we don't subscribe to that kind of deal for clients. But more generally, cases tend to settle in close proximity to that listing, don't they, when the matter's listed for hearing?
That's right, because by the time you get to that stage, we've got to carry out our expert report for the client that goes to the tribunal for them to actually use as the basis for the case. But the freeholder's valuer has to do the same. And at this stage, all these preparations are costing both parties money. It's no longer a case that the leaseholder is paying for these costs of negotiation.
There's no cost shifting at the tribunal.
No. So therefore, when the freeholders have to start putting their hands in their pockets to pay for these cases to go to tribunal, they're wanting to make sure that A, they've either got a very strong case to make it worthwhile, or B, actually no, they don't want to do that because it's just taking off the bottom line, so they might as well agree the case. And that's why often we have to make.
But it's more than that, David, isn't it? It's really down to the fact that the client's team, their legal and their valuation team, are ready to go.
Well, yes,
we're ready to. When it comes down to it, you and me. Mm-hmm. So from the legal side, I'm ready to go to tribunal if the freeholder wants to push it, and
that was
that's and without that kind of without that force in place, that consequence, I don't think that you could get the optimum deal.
No, that's very true.
So it's really good, David, that we've gone through, from start to finish, really the 93 Act process for lease extensions. I'm sure our audience, will take something away from this. Thanks very much, David.
No problem at all. Thank you.